This conference will now be recorded.
So I'd like to welcome everybody who's joining me today. It's Friday, December 4th, 2020, to my webinar, How Elder Law Attorneys Help Real Estate Professionals. And my goal today is to establish a network of professionals that can collaborate together to do the best possible value-added service for our clients. And we're going to walk through a few different scenarios of challenges that can arise in a real estate transaction, how to solve them, and I'm going to leave you with some planning tips at the end. So just a little bit of background about me for those of you who are joining me for the first time today. I am reaching my almost 30th year of practicing elder law, which I very much enjoy. I became board certified in this specialty early on in 1995. I was certified nationally by the National Elder Law Foundation, and this was before the Florida Bar had developed a board certification program for elder law. So a few years later, I was grandfathered into Florida's board certification program. I also served as what's called the chair, which is similar to an office of the president, for the Florida Bar's Elder Law section, and worked with many different legislative representatives at that time, which was a great way for me to understand the process of creating a bill, how it's evaluated by the different factions within the Senate and the House, and how it then becomes a law. So it gave me great insight to understanding how bills that are proposed that are going to affect my clients can receive the input from the elder law attorneys. I have a very broad elder law practice, and I chose that for the specific reason that while a client may walk into my office and say that they have an estate planning issue or they have a probate issue, many times those issues touch other areas of elder law. So my practice includes not only estate planning for people of all ages, all ethnicities, but I also handle guardianships for minors who perhaps inherit assets from a relative who have passed, as well as guardianship for adults who become incapacitated. I also handle the probating of estates when people pass away, as well as guiding their families through the process of administering their revocable trust when they pass. And I have incorporated in my practice working with individuals who have disabilities, whether they were born with a disability or they were born healthy, but then there was an accident or a disease. And that involves also special needs trusts and helping them qualify for government benefits, such as Medicaid, veteran benefits, Social Security benefits. One of the things I learned early on in my practice is that clients are not one-dimensional. So again, they walk into my office, they're here for legal advice, but the reality is that when somebody encounters an aging challenge, it affects every other area of their life. So I learned very early on the value to the client and to me of collaborating with other professionals so that we develop a team for the client to identify all the issues, create the game plan, and help the client meet their end goal. That's the way we can be most effective for the client. So because the client is multidimensional, there are many different areas of their life that have to be addressed. There's the legal, the real estate we're going to talk about today, the financial planning aspect, the accounting and taxes is always an issue that constantly arises in the elder law practice. And there's the personal care side. So they have medical issues that need to be resolved, social issues, psychological. And for that, we need a well-informed team that will include the real estate professional, the attorney, the accountant, perhaps a care manager, as well as a physician. So I'd like to start today's webinar talking about the most frequent real estate challenge I see in my practice, And if anything, it's increased, unfortunately, since COVID-19 came to the United States. And that is what to do when the homeowner is incapacitated and a sale needs to be consummated. So I'm going to share with you a real life experience that came up in April of this year. I received a referral from a local real estate attorney who was hired by the adult son of the homeowner. Now, the homeowner was an older woman, unfortunately diagnosed with advanced Alzheimer's. And at the time, she was living in a nursing home in Georgia, where her son lived. And he contacted me because the home was solely in his mother's name, and he needed to be able to do everything that arises in the real estate sales transaction. So he had already signed the listing agreement. The realtor had found the suitable buyer. They had agreed on a sales price, but everything stopped at that point. Now, what I learned was that once he brought his mother from Florida to Georgia, he consulted with an attorney in his town, and he became the court-appointed guardian of his mother. That allowed him to make both her medical decisions as well as her financial decisions. And the reason he became guardian is because prior to the onset of the Alzheimer's, she had either not known or not been informed about the importance of having certain legal documents in place. So without those legal documents, his only option was to become a guardian. Now, he worked with his attorney in Georgia to get the Georgia court to permit him to sell his mother's home. However, because the home was located here in Florida, the Georgia court didn't have any authority over the Florida property. And that is why he was referred to me. Well, we had some good news, and that was because there was already a guardianship in place in Georgia. We were able to file limited number of pleadings here in Florida with our Broward County probate court to get the judge to allow him to continue and complete the real estate sale. So within a fairly short time, we were able to complete that process, get the court orders to the real estate attorney and the title company, and he was able to successfully complete that transaction and is now using the money to take care of his mother and to meet her expenses. So in that situation, the solution was that we did have to open a court proceeding here in Florida. But I'm sure you're asking yourselves, how could that guardianship have been avoided in the first place? So one of the most important tips I'm going to leave you with today is that everybody over the age of 18 should have a durable power of attorney. This is a document in Florida that gives legal permission to somebody you trust to make your financial decisions for you should you become incapacitated. Now, what does incapacity mean? Well, it could mean that you were in a car accident and you are physically injured, and that's impacting your ability to go to the bank, to sit down at the computer and pay your bills on time. You're not feeling great, so maybe you don't have the energy to call your financial advisor to talk about how your investments are doing. Or it could mean that something is impacting your cognitive abilities, your ability to reason, to exercise good judgment, to understand different aspects of investment strategies and the possible outcomes, and to make an informed decision. Now, why would that occur? Well, again, let's use the car accident example. You might have been injured, your head could have hit the dashboard, hit a window, and there's some trauma. Or perhaps there's an illness that occurred. So if you are physically or cognitively incapacitated, you might not be able to carry out your day-to-day financial affairs. Well, we wouldn't want things to just stop. We want things to continue to flow. So we need a financial management plan. And the durable power of attorney is one of the tools that is available to create that management plan for you. Now, sometimes people ask, well, I don't want to give anybody the ability to become an owner of my assets. Is that going to happen if I sign a durable power of attorney? And the answer is no. You are not making the person you name as an owner. You are naming them as what we call in the law a fiduciary. So they're being held to a high standard of care in taking care of your assets for you. So one of the nice things about the durable power of attorney, as opposed to adding somebody's name onto your account as a joint owner, is if that fiduciary has a financial problem. Maybe they're using credit cards too much. Maybe they caused a car accident, or maybe they're getting a divorce. Their financial issues are not going to impact your assets. That's one of the reasons why it is a better solution than just simply putting somebody's name on your account as a joint owner. Because as a joint owner, they're going to have equal access as you do. And if they do have a financial hardship, half that account is available to their creditors. So what are the requirements to create a durable power of attorney? Well, the primary one is that you must understand what you're doing by signing the document. Somebody who is not cognitive is not going to have the option of a durable power of attorney. So it is much more than simply, can a person hold a pen in their hand and sign their name? They have to be aware. They have to understand what they're doing. And not all durable powers of attorney are written the same way, nor are they written in a way that's going to help a client. So I'm going to take a second from where we're going and just explain that there is a different approach that an elder law attorney has compared to a traditional estate planning lawyer when we write a durable power of attorney. An estate planning lawyer's training has them focusing more on assisting clients with passing on assets at death and how to minimize taxes, compared to my training, which is focusing as much, if not more, on what happens while people are alive and they get older than focusing just on death. So when I write a durable power of attorney, I'm thinking, what if my client becomes incapacitated and the person they named needs to deal with each type of asset that we know now they own? That could be real estate. It could be an IRA or a 401k. It might mean that they're still filing federal income tax returns, and so we need the fiduciary to have authority to sign that 1040 or 1041. So the outlook is different in how we write the document. And I'm going to encourage everybody who's with me today, if you have a client who says, I'm just going to go on the internet, I'm going to go to LegalZoom, tell them not to. It's going to cost them more in the long run than it is if they go to an elder law attorney now and they have it done correctly. So let's say you have a situation where you have been hired not by the homeowner, but let's say by an adult child of the homeowner to sell the home. And your listing agreement is signed, but shortly after that, you realize that the homeowner is incapacitated. What do you do? And what can you do in order to consummate the sale and earn your commission because you've been putting in all this time and effort? Well, if the homeowner is incapacitated and it's not possible for me to write a durable power of attorney, then we want to get the guardianship initiated as soon as possible. So I want to walk you through the process so you understand the time frame and what is involved in Florida to initiate a guardianship. So the process begins by electronically filing paperwork that tells a judge, why is this person incapacitated? And we need to give examples, and we need to provide information about people that have firsthand knowledge. So that could be the adult child, it could be the individual's physician. Perhaps they've been evaluated by a neurologist. We file that, and what happens in the court once they open the file and they assign a judge is they're going to schedule a hearing 4 weeks later. So keep in mind there may need to be an extension on the real estate contract because your closing date might be prior to when we're actually going to have the hearing to appoint the guardian. So that's one thing to keep in mind. Now you might be asking, well, why does it take 4 weeks just to get to the hearing? Well, there are certain very important steps that happen during that 4-week period. The first thing is that the clerk of the court is going to appoint 3 medical professionals to sit on what is called the examining committee. We have a medical doctor, we might have a nurse, we might have a licensed clinical social worker, we might have a neurologist, or another medical professional. Their job is pre-COVID to go out, meet with the individual, and do an assessment. After the assessment, they write a report to the judge and to the attorneys telling us what did they observe, how did the person answer questions, is there a diagnosis in place, and does this person need a guardian? And if they need a guardian, what rights should be taken away from them, and what rights can they still keep and properly exercise without being taken advantage of? And the rights we're talking about include the right to vote, the right to marry, the right to travel, the right to sign a contract, the right to apply for government benefits, the right to file a lawsuit or defend a lawsuit that's filed against you. So they need that time for each of the committee members to go out and do their assessment. Now, since COVID, we are presented with this dilemma that it's not necessarily safe to go out and do the assessment. So many assessments are being done through video or FaceTime. And then the doctor and the other committee members are able to write their report. Now, the other challenge we are facing during COVID is that many of the medical doctors that sit on the committee aren't as available as they once were. So sometimes it could take longer than 4 weeks for the hearing to take place. The other thing that happens during the 4-week period is that the clerk appoints a lawyer in the community to represent the person that is allegedly incapacitated. And we do this because a person's rights should not be taken away until they are proven to be incapacitated. It's similar to our criminal justice system. A person is not assumed to be guilty until there is a trial and the proof is presented beyond a reasonable doubt that they committed the crime. So that attorney also needs time to meet with their client, and if they believe that the client is not incapacitated, they need time to create their defense and present witnesses and evidence at the hearing. When the hearing does occur, there will be evidence and testimony taken. And if we meet our burden of proof of establishing that this individual needs a guardian, then the judge will sign the order to appoint the guardian. At that point, we can get the real estate attorney and the title company a certified copy of the signed guardianship paperwork so that the sale can be completed once the judge reviews the paperwork pertaining to the sale. So you can see that guardianship is not the option we really want to resort to first, but it is sometimes the only option if the person did not do proper planning when they were mentally competent. Now, a couple of things to keep in mind as to why we want to use guardianship as a measure of last resort is it does take time. Number two is a guardianship can be expensive. And the reason for that is that the lawyer is not involved just in the initial phase of getting the guardian appointed, but the court continues to oversee the guardian, and a lawyer must continue to represent the guardian throughout the lifetime of the incapacitated person. So for some people, a guardianship can go on for many years. especially if the person is cognitively incapacitated, but physically their body is fine. I've had guardianships that have lasted for 15 or 20 years. And so there is that ongoing legal expense. So you can see that's another reason why we like to look at it as a measure of last resort. Another thing to keep in mind is that people tend to lose a lot of their privacy when we file for a guardianship. Many things are a public record, even now when the court records are electronic. You can sit at home, go on your computer, type in somebody's name, and you will be able to see a lot of the documentation that is filed. So again, my suggestion is to encourage people to do planning while they're healthy, while they're cognitively intact, and never have to go through the guardianship proceeding. The second challenge that I see most frequently with real estate involves facts when the homeowner dies, and there is a need for the home or another piece of real estate, it could be a rental property, to go through the court system that we call probate in order for the beneficiaries to then have the ability to sign the documentation to sell and complete the sale. So let's start with the basics. Why would the home or the rental property need to go through the court process called probate? Well, it all boils down to how is the deed worded? Who is the owner? Are there any joint owners? Are there beneficiaries named on the deed? So the rule of thumb is that an asset, whether it's real estate or something else, titled just in the name of the decedent, with no joint owners and no beneficiary, is going to need to go through the court process in order to get to the beneficiaries. And this is the rule even if the person who passed away made a last will and testament. What the last will and testament achieves is being able to exercise control over who's going to inherit the asset or how much they're going to inherit, or disinheriting certain people that you don't want to include in your affairs. It also allows you to name the personal representative that will have the responsibility of overseeing your affairs, gathering the assets, identifying creditors, and then distributing the assets at the end. But the will does not mean you avoid probate. It all has to do with the ownership of the assets. Now, I hear at least once a week people say, oh, I've heard horrible things about probate. I've heard it's expensive. I've heard that it takes a long time. And I like to refer to those as the probate myths and rumors because that is not entirely accurate. We have several different forms of probate in Florida, and determining which one is right for the person who died is based upon what kind of assets they own and the value of the assets. So just to give you a couple of examples, if somebody owns a home and they don't have any other assets or their other assets named beneficiaries, we can use one of two types of probates. We can use a formal administration, which takes about 3.5 months. The benefit of the formal administration is we go through a process of having the court declare the property to be homestead, which means then it is protected from claims of creditors. Creditors such as medical creditors, credit card creditors. The creditors who are able to reach the homestead would be the mortgage lender. If the mortgage was defaulted, it hasn't been paid, or what is called a mechanics lien. So if the homeowner had work performed on their house, let's say they hired a roof contractor, but they didn't finish paying the contractor can put a mechanics lien on the home. Those are the two exemptions. Other creditors cannot reach the homestead once the court makes an official determination. One of the other advantages of doing a formal administration for real estate is that we publish a notice in the newspaper. So let's say that we don't know all the creditors that exist. The personal representative went through the mail, they look through the person's wallet for credit cards, and we want to make sure that anybody else who's out there that we don't know of won't come forward and try to put a lien against the home. By publishing this notice to creditors in the local newspaper, that is how we get around any other creditors, because they have a limited period of time, 3 months, to file a claim with the court. If they don't file the claim or they file it late, then their claim is barred. So the homestead is protected. The second type of probate we can do for real estate is a shortened proceeding called summary administration. Now here we can also have the judge make an official determination that it's homestead and it's protected. However, it is not required to publish the notice in the newspaper. And this is where some people make a bad decision not to spend the money, which is usually under $200, to publish that notice. And it means that the beneficiaries are then on the hook for 2 years after the homeowner's death. So if a claim comes in that 2-year period, they are responsible for payment of that claim. So just to recap, we have different types of probate proceedings in Florida. It will depend on the type of assets and the value. If the value of the assets other than the home are greater than $75,000, we're going to want to use the formal administration process. The value of the home doesn't get counted in a probate as long as we can prove that it should receive homestead protection from claims of creditors. And how we do this is to show documentation that the decedent lived there, they treated it as their home. We might need to show utility invoices, a voter's registration card are some of the most frequent methods that we use. So when we're dealing with probate and trying to sell a home of a person who died, sometimes what comes up is, can the home be sold? Can it be conveyed? So we're going to go over, what does the Florida Constitution say about the home? Well, the Florida Constitution protects the home for the owner, the spouse of the owner, and any minor age children under the age of 18. If the homeowner has a spouse or a minor child, the homeowner is not allowed to just sell their house because it's meant to be protected for the spouse and the minor child. Let's say they don't have a minor child, but they do have a spouse. In order to be able to sell the property, the spouse is going to have to join into the sale. They're going to have to agree in writing, or the other way to do it is they can sign a waiver to their right. Now, this has to happen even if the spouse's name is not on the deed. And we do see this a lot, usually after a first marriage, a second or a third. One of the spouses was living in the marital home. The deed is titled just in that spouse's name, and either they never thought to add their spouse's name on, or they purposely chose not to. They're trying to keep assets separate. Well, believe it or not, once they get married, the other spouse has a constitutional right to homestead, even if their name is not on the deed. And that's why, to complete the sale, that spouse or the surviving spouse has to sign on to all the documents, or they have to, in writing, waive their inheritance rights to have anything to do with the property. So again, what is helpful here is having the durable power of attorney. It helps us while people are alive. And it's also important that people consult with a real estate attorney as well as an elder law attorney if they're going to get married, to understand what their rights are under the law to the home. Now, can probate be avoided? It's a frequent question that's asked, and it's a very important question. So one of the ways to safely avoid property that is the home, and protect the rights of the homeowner would be through a revocable trust. This is a legal document that is created by an attorney that can make the homeowner the trustee, so they're still in charge of everything. They're in control, they're making the decisions. What's nice and beneficial about the trust is the document doesn't get filed anywhere. It's not getting filed in court, so it's not a public record, and it's generally not going to get recorded in our public records either. So compared to the guardianship, it does help people maintain their privacy and their confidentiality, and it serves that dual purpose that we talked about with the durable power of attorney. It creates a financial management system because in the document, we identify an alternate trustee, somebody who's going to step in and handle the financial affairs if the primary trustee becomes incapacitated or when that primary trustee passes away. So that's the second benefit. However, there is no protection from creditors. So if somebody's going to go to a lawyer and have a revocable trust created thinking they're not going to have to pay their credit cards, that is not the case. Because the person who owns the assets is creating the trust and putting their assets into it, and they have control, there is no protection from claims of creditors. So that's something to just keep in the back of your mind. Now, it's not enough to just go to an attorney, such as an estate planning lawyer or an elder law attorney, and have them write the document. There's actually a second equally important step that has to be taken, and that is what we call funding the trust. It means to put the ownership of the assets into the trust. Otherwise, the trust is an empty shell. It hasn't been funded. So if somebody is interested in putting title to their home into their revocable trust, we do this by writing a deed and recording it. We do want to keep some ownership in the individual's name so that they keep their homestead tax exemption. What should we do, however, if the home is owned by a married couple? Well, we might not want to put the home into two separate trusts, or if they're going to have a joint trust, we might consider doing that. Or we may just want to wait until one of the spouses passes, and then at that time create a trust for the surviving spouse and write a deed to transfer the ownership of the home into that trust. Every person's situation is different, marital status, financial level, and all those factors should be evaluated to determine what is right for each client. The third challenge that I see most frequently with real estate has to do with people who are usually older, but not always, they could be younger, who have gone through some sort of a chronic long-term illness, and now they need long-term care, and they're faced with the dilemma of how are they going to pay for that care. And so people then start to explore Medicaid. Medicaid is a financially funded program that provides healthcare services. So if somebody had a chronic illness, could be Lou Gehrig's disease, could be Alzheimer's, and it's not safe for them to stay at home anymore, the family might explore a community such as a memory care center or assisted living or a skilled nursing facility. And so as they explore, can their loved one qualify for Medicaid, they're going to want to be informed about what are the financial requirements and can we protect the home? That's usually the first question people ask. So to qualify for Medicaid, there are limited countable resources a person can have. If they're single, the countable resources are limited to $2,000. If they are married, then the assets of their spouse are going to be looked at by the Medicaid agency as well. The spouse can have a greater amount of assets. Currently this year, that figure is set at $128,640. And the reason I said this year is because that figure will change each January 1st. So We're at the tail end of this year. We have new figures that are going to be coming out for 2021. Now, there is an income limit for the person who seeks to qualify. There is no income limit for their spouse. They can have as much income as they possibly can. But Florida does set an income limit, and income includes your employment if you're working, your Social Security, disability, or your Social Security retirement benefit. It includes pension. It includes an IRA distribution or a 401k distribution. So if somebody has gross income that is over the limit, they can still qualify, but there's more planning that we have to do to meet the Medicaid requirements. Another very important qualification I want to mention to you is there is a 5-year look back. Now, this is federal law. This is not just the state of Florida. The look back means that when a person applies for Medicaid, the application will ask them, did you give away your assets? Could be the home, could be rental property, could be a cash account. Did you give away an asset within the last 5 years? If you answer yes, which you should because you don't want to commit Medicaid fraud, that's a criminal act, they're going to ask when and what was the value of what you gave away. So why am I bringing this up? I'm bringing it up because we all know there's a lot of information available on the internet. However, it's usually not accurate. And the last thing I want your clients to do is to sign their home or rental property over to a family member thinking it's going to help them qualify for Medicaid, and in actuality, it's going to create a problem and they're going to be disqualified for Medicaid. So let's talk about the treatment of the home under the Medicaid rules. What happens? Well, luckily here in Florida, we have a number of resources that are exempt, meaning Medicaid does not count their value. And the first and most important one is the home. So Florida has set an asset limit for the value of the home currently at $595,000. If there's any debt on the home, that debt would be subtracted to then determine if the value of the home is exempt or not. So now that you know the home is exempt, the last thing we want is somebody to sign a deed and convey the property to a family member. That is taking the home out of its exempt status, and it's a transfer, which is going to affect the homeowner, and they're not going to qualify for Medicaid right away. Another type of exempt resource that all our real estate professionals need to know about is what's called income producing property. This is another way of saying rental property. So let's say somebody you know needs to qualify for Medicaid because they have a chronic illness and they have a home which is protected, but they have cash resources, and that is putting them over the limit to qualify. We might want to explore with your assistance having them purchase rental property and renting it out, because if it's rented, then the government won't count that as a resource. So that is one option that we can use as a planning tool to help that person qualify for Medicaid assistance. Another exempt resource is the car. So Medicaid will exempt the first car, regardless of age or value. And if there's a second automobile, they will exempt that as long as the car is 7 years of age or older. What if your client has an IRA or a 401k? Well, here in Florida, again, I think we have some of the best Medicaid rules in the entire country. If the IRA owner is going to take required minimum monthly distributions, then the IRA or the 401k will be exempt. It will not be counted. Now, I know sometimes we have tax professionals or accounting professionals listening to this webinar, and what I'm saying might not make sense with the Internal Revenue Code, which says you could take a distribution once a year and it'll represent 12 months worth of payments. But Medicaid has a different set of rules. So Medicaid wants to see the distributions occurring on a monthly basis. So if we work with their financial advisor, Betty, I'm going to mute you. Thank you for joining us. If we convert the annual distribution to a monthly, that is one of the easiest ways to save the IRA or the 401k from being counted as a resource. So keep that in the back of your mind should you know of somebody that's going through this kind of situation. Now, we do have a new law. It's not really new, but it might be new to you. It's been in place several years. This is a federal Medicaid rule, and that is if somebody has an annuity, which is an insurance product that has been purchased after a certain year, then this could be a countable resource unless the owner is willing to first name the state of Florida as the beneficiary for any remaining value. Now, they have to do this if there's no spouse and there's no minor or disabled child. But if there's a spouse, the spouse can be named first and the state of Florida named second. Another type of exempt resource, I know this might be a surprise, are funeral arrangements. And while this is not a pleasant topic for any of us to discuss, when somebody is going on Medicaid, it is important to set aside funds to pay in advance for a funeral. So as long as the contract is properly worded and we need it to be irrevocable, which means that if you change your mind after you purchase it and you want to make changes and it's going to cost less money, the funeral home is not going to refund you the difference, then those funeral arrangements will not be counted as a resource by the Medicaid agency. Now, I do hear a lot of questions arising after the homeowner has been approved for Medicaid, because at some point in time, families are going to be faced with the question of, can we keep the cost going of maintaining the home? What if we can't? What can we do? And how is it going to impact our loved ones' continued Medicaid eligibility? So one of the first things we would want to explore with the real estate professional's assistance is, could the home be rented? And the reason we want to explore this as an option is, remember I said the home is an exempt resource. As long as the value is under $595,000, it doesn't count. And even though the homeowner may no longer be residing in the home and may need to be in a facility, Florida still protects the home. And that is because we have these wonderful, strong Florida constitutional homestead protections. And that protection continues even when the homeowner dies. And even though they've been on Medicaid, Medicaid cannot put a lien on the home. If anybody tells you different, they are giving you wrong information. So we really want to try not to sell the home if we can help it. That's why we want to explore the possibility of renting the home. Now, when I talk about renting, we want to rent it for nothing more than a year. And the reason for that is we want to be able to say to the Medicaid agency that the homeowner intends to return home. Not that they have to physically or medically be capable of returning home, but there's the intention to do that. So we wouldn't want to lease greater than a year because it negates that intention. Now, one thing to keep in mind with renting a home is we're not necessarily looking to make a windfall, to make a profit, but really just to cover the operating expenses, the real estate taxes, the homeowner's insurance, the utilities, if there are any association dues. And what the Medicaid agency will allow is to have the expenses of operating the home deducted from the rental income, and then they'll look at the net rental income. Remember I said a little while ago, income is looked at in order to determine if somebody qualifies. But what if renting just won't work and the family decides the home needs to be sold and they come to you? We want to work together because timing is so important. the timing of the closing is important in relation to keeping that person on their Medicaid benefits. So we want to, before the closing occurs, go through a process of evaluating what are the options? How can we protect those sale proceeds so this individual doesn't lose their Medicaid? Because the fear for many people, and it's a reality, is the person could outlive the value of the sale proceeds. So two types of trusts we are going to explore that are exempt and can protect the sale proceeds are a special needs trust and what is called a pool trust. It's a variation of a special needs trust. Now, by law, we can use a special needs trust for our clients who are under age 65. Once they're over 65, that option is no longer available, and that's when we want to look at the pool trust option. So I'm going to explain to you some of the similarities and some of the differences. So the similarity is that once the real estate proceeds go into these trusts, they're not counted. And so the Medicaid recipient continues to qualify ongoing for Medicaid assistance. Both are the same in that the goal of putting the monies into these trusts is for the monies to be used to enhance the quality of life for the Medicaid recipient. So what could it be spent on? Well, it could be spent on the cost of a private duty room because Medicaid is only going to pay the facility for the cost of a semi-private room. Or perhaps we might want to use the real estate proceeds to pay for a private duty home health aide or a companion, maybe because the adult children don't live in Florida. They're located elsewhere in the country. And that's a way that they want to give better quality of life to their parent or their grandparent or their loved one. Or perhaps somebody is getting married in the family and they want this relative to be able to attend the event. We can use the money to pay for the travel expenses, the hotel, having the hired home health aide accompany them on their travels. Anything that's going to give the person better quality of care and quality of life is a permissible use of the assets placed in the special needs trust or the pool trust. The main difference between these two types of trust is who can be the trustee. So with the special needs trust for somebody under age 65, they can choose their own trustee. They can select a professional trustee like a SunTrust, a trust company, or they can choose to have a family member be a trustee or an accountant be a trustee. However, the law says that the pool trust can only be managed and operated by a charity, not a person. So it still works the same, except we would have the power of attorney or the legal representative for the individual communicate with the trustee so they know when something is needed. Both of these trusts are going to operate in the same way. The trustee is not going to put any money in the hands of the Medicaid recipient or their legal representative. The reason for this is if we put money in their hands, it counts under the Medicaid rules. Instead, the trustee is going to pay the vendor who is providing the service or the product to the Medicaid recipient. So by doing it in this way, the Medicaid recipient maintains their government benefits. Now, the other similarity, and this is important to understand between these two types of trusts, is the federal law says that when the Medicaid recipient passes away, any monies remaining in the trust must first go to repay Medicaid for the benefits it paid out during the person's lifetime. If the individual used up all the real estate proceeds in the trust, that's it. That's the end of the story. Nobody else is responsible for repaying Medicaid. If there are monies left, those monies first repay the Medicaid lien, and then if there are still any monies remaining, they will go to whoever the individual designated in the trust agreement. So it can go to family, it can go to charity, it can go to anybody that they choose. So my experience over 30 years is we are getting the best benefit of the bargain here because it's helping people get better quality of care and quality of life. And if there's nothing left, then Medicaid gets nothing at the end. So we're towards the end of our webinar, and I want to take a couple of minutes and talk about how titling, how ownership impacts all of these situations that we've just discussed. And there's many different ways to write a deed. There's different ways to own a home or own rental property. One of the types of ownership I want to share with you because it's really important and it achieves a lot of the goals we've talked about today is called the enhanced life estate deed. In my profession, our nickname for it is called the ladybird deed. Now, this is different than a traditional life estate deed, and I'm going to explain how. In a traditional life estate deed, the ownership is divided between two people. The owner has the life estate portion, and the other people have what we call the remainder. And for those of you out there who are visual people like myself, think back to when we were in grade school math class and the teacher drew a pie, a circle on the blackboard, and they cut out a slice. Well, that slice is what we call the life estate, and the rest of the pie is the remainder. So the owner who has the life estate, if they wanted to sell it, they would have to get the consent and permission of the remainder beneficiaries. If the remainder beneficiaries don't want to sell, then the life estate owner is out of luck. However, the way an enhanced life estate deed is written is there is specific language that says the life estate owner does not need the consent or permission of the remainder beneficiaries to sell it. And if the owner does sell the property, they do not share any of the sale proceeds with the remainder beneficiaries. So the remainder beneficiaries would only get the home when the owner dies if they still own that property. Now, one of the things I like about the enhanced life estate deed is it's very helpful for people that need to apply for Medicaid. Remember we talked about the transfer, the 5-year look back? Well, this kind of deed doesn't cause a problem with that look back period because they're not giving up any ownership now to their family or their beneficiaries. They are 100% in control. They own 100% of the home. They haven't given anything away. So these deeds are really great when we need to help somebody qualify for Medicaid. It also achieves the goal of having the property avoid probate because we can designate beneficiaries on the deed. However, and here's, I'm always going to tell you the pros and the cons. Here's one thing to be aware of. If the remainder beneficiaries have creditors or have judgment liens that have been entered against them, I would not advise using this deed. And I'm going to give you a real life example why that happened this year. I represent a guardian. She is the guardian of her mother. And right before COVID hit, she got permission from the guardianship judge to sell her mother's home. And she hired the realtor. She signed the listing agreement. Realtor found the right buyer. And when the title company was doing the title search, they found that there were 2 remainder beneficiaries named on the mother's deed, the daughter and the son. And lo and behold, the son had an IRS tax lien against him, and he had several judgment liens entered against him. And the title insurance company would not write the policy, they would not complete the sale unless the guardian agreed to allow them to hold in escrow the amount of the sale proceeds equal to all those judgment liens and the tax lien. And what ended up happening is my client had to hire a real estate litigation attorney who had to file a federal lawsuit against IRS and all those judgment creditors and present an argument to the federal judge as to why the creditors of the son should not impact the mother. Now, we were very fortunate and we won that federal lawsuit, but it took months and the process was also slowed down because of COVID. Now, in the end, everything worked out fine and all the real estate proceeds have been put into the guardianship, but we don't want people going through that kind of hardship. Now, I have recently read that there is a new title standard that says in that type of situation, the creditors of the remainder beneficiary cannot attach the proceeds. But I think that it's probably best not to use this deed if we know the beneficiaries have creditor issues. Now, another way to own real estate is what is called joint tenants with right of survivorship. And what this means is we have multiple owners, co-owners. Each owns the same, usually the same percentage, and they have equal rights. So if one wants to sell, but three say no, guess what? It's not going to happen unless we go to court and we file for what's called partition. So we always want to evaluate pros and cons to each type of real estate ownership. Yes, it will avoid probate because the survivorship language in the deed says that when one co-owner dies, their share is automatically inherited by the other co-owners. But what if you don't want your co-owners to inherit your share? What if you want it to go to other people? Well, if you don't know this information and you don't take the time to go to either a real estate attorney or an elder law attorney, then unfortunately you're going to unintentionally disinherit the people you wanted to inherit your share of the ownership. So there's a lot of factors that have to be evaluated to decide what is the best way to write the deed to achieve a person's goals. A third type of ownership is what we call tenancy by the entireties, and this is specifically for married couples. It can only be used for married couples. Again, like the joint ownership with right of survivorship and the enhanced life estate deed, it does help people avoid probate. However, one spouse cannot convey ownership without their spouse consenting or waiving their rights. So that's important to keep in mind if people are in a marriage subsequent to their first marriage, if maybe they have a prenuptial or a postnuptial agreement. The last type of ownership that we're going to explore is called tenancy in common, and it means we have multiple owners. They may or may not have the same fractional share, but it does let you choose who's going to inherit your share rather than there being automatic inheritance through survivorship. So if I was a tenant in common with a best friend, but I wanted my daughter to inherit my share, it could be worded in that way so that when I die, it would go to my daughter through my last will and testament. One of the downsides is it's not going to avoid probate, but again, that is not necessarily the most important thing to weigh in the big picture. You can buy out your co-owner, but again, that's going to depend on whether people are getting along. And you can transfer your share of the property without asking for the consent of your joint owner. However, then that other owner may or may not want to own the property with this new person that they may not know. So all of these factors need to be evaluated to determine what's the best way to write a deed for me. So in closing, I'd like to leave you with a couple of important tips. And the first is there are solutions when challenges arise affecting a real estate sale. We want to encourage our clients to plan ahead because when you plan ahead, you have more time, you have more legal options, and you can avoid emergency expenses such as the expense of a guardianship. And most important, we can't put a value on what our privacy is worth. Keep in mind that in Florida, at age 18, everybody becomes a legal adult. So when we send our kids off to college, believe it or not, we're not allowed to make their financial decisions for them. So it's important that they also have a durable power of attorney before they leave home. And what we call a designation of healthcare surrogate for medical decision making, especially in this time of the COVID-19 pandemic. And probably the most important tip I can leave you with is do discourage clients from doing it themselves. Usually the document is not going to come out correct. It's not going to have the language that they need to complete a real estate transaction, or it might miss the right number of witnesses or not be notarized. And when it's time to sell the property, if the homeowner is no longer mentally competent, we're going to be dealing with the problem of going to court and doing a guardianship. So at this time, I'd like to invite the attendees to unmute their microphones, ask a question, or use the chat box. Well, if there are no questions, I'd like to thank everybody for joining me today. And keep in mind, we host 2 webinars each month. Please go to my website, to the events calendar page to register. And if you wanted to attend a webinar but something came up and you missed it, you can either go to YouTube or to our webinar page and watch the recorded webinar. And don't forget that we do have a gift certificate listed on the website that you're welcome to use for yourself, your clients, your loved ones. Steve, I see you've unmuted your microphone. Would you like to ask a question?
No questions, just wanted to say thanks, and I think we're going to have to consult.
Okay.
I have an 85 and an 87-year-old parents that I know have no documentation regarding anything, and so I know we're going to need to get together.
Well, I look forward to it. And you know what? It's the right time. It's December. We should all be thinking about our New Year's resolutions. And as they say, there's no time like the present.
Well, thank you for all the information. Very informative today.
You are welcome. Well, I want to wish everybody a great weekend. Oh, Maria, I see you've unmuted your microphone.
Yes. Thanks. It was very, very good. I wanted to ask because I have my grandmother-in-law that has a property. She's not for Medicare or anything, Medicaid or anything, because she didn't work in here. I mean, she's American, but she's not, she doesn't have the right for it. But she has a property in Orlando, and she lives in Miami. And her husband died 5 years ago, but we haven't changed the names. And is that something, she has to go there and change that, or can we do it through internet? Do you know anything about it?
Okay, so it's a great question. Thank you for asking it. She does not need to travel to Orlando. We can do it locally. And what we'll want to do is a process first called clearing the title, meaning we will want to record her husband's death certificate. And there is a Department of Revenue tax affidavit we'll want her to sign and record as well. And then we'll want to have a discussion about perhaps writing a new deed to achieve whatever her goals are, whether it's avoiding probate or planning for Medicaid down the road. And so we can do all that locally.
Okay. Thank you. I will tell my husband about it, and, we'll get in contact. Okay?
Okay.
Thanks a lot. Really.
You're welcome. I look forward to meeting you.
Yeah.
Well, have a great weekend, everybody. Stay safe, stay healthy, enjoy your holiday, and have a great new year. Thank you for joining me today.